retired judge, Justice Dave Smuts, to just reflect really on his work, particularly from the civil society position and the reflections and philosophical musings around the construction of our Constitution and the administration of justice under the Geingob administration. Very good morning to you, Justice, and thank you so much for making time out to join us.
Good morning, yeah.
Well, if we can take a step back, of course, I know we're meeting under really difficult circumstances. We would have loved to have these sort of conversations under normal circumstances, but here we are. How did the news of the president's passing reach you, and what were some of your immediate reactions to that news?
Yes, I heard the news actually very early that Sunday morning when I was walking my dogs. A colleague called me to tell me the news, and I was completely shocked. It was so sudden. It was something which, although he'd announced that he was suffering from cancer, it was nothing that we expected. And so, of course, it came as a huge shock and very, very sudden, and left so many of us with a huge sense of loss.
If one looks at it, just take a step back and look at your early encounters with the late president. What were some of your initial or early encounters with Geingob the man?
Yes, I actually came to know him only in about 1989. I knew a lot of other people in leadership positions before that, and for some reason our paths had not crossed. I met with several of the other, like the late Theo Ben-Gurion, the first president, and the late Tedipo Hamatenya, but our paths had not crossed. And then I met him in '89, and my late friend Anton Naboski very badly wanted me also to meet him because he was so impressed with him. And so I did, yes, I met him in 1989, and at the time when he was going to be put in an incredibly important position as heading the Constituent Assembly's Constitutional Committee. And it's from that time that I've really gained a lot of respect for him, and particularly because of his seminal leadership role in ensuring that we got the Constitution we have, and in such an incredibly short space of time. I was completely overwhelmed by the fact that in about 6 weeks, flat, that committee had thrashed out a constitution which completely stands the test of time. And they did it incredibly well in such a short space of time. And this, I think, had a lot to do with his leadership. It was unanimously adopted. And the way he ran that, and the way in which he steered those deliberations to embrace democratic and the constitutional values which you find in our Constitution is really impressive, and I think that will be his lasting legacy for the country.
Looking at that as well, of course, particularly during the time you were practicing as a human rights lawyer, reflect on the importance of the inclusion of Chapter 3 in the Constitution and the kind of importance that has been given. Of course, you can't just change it according to the whims of, or have some arbitrary decision to change any of the rights that are provided and freedoms in there. Reflect a little bit on the importance of including it in the way it was provided through Resolution 435 and the sanctity that it carries, Chapter 3, in the respect for human rights.
Yes. That chapter is of pivotal importance to the Constitution. It enshrines basic rights, and as you've indicated in your question, it cannot be amended. You can't amend it to detract from those rights. And those are very powerful provisions in a constitution, because often constitutions can be adopted and can sound and read very well, but when there's a little bit of stress and tension, they get amended, and a lot of the rights which are given in the Constitution are taken away. You can't take away those rights. And I think that's one of the most important provisions in the Constitution. And it was really incredibly important for the country coming from a history where human rights were so badly abused, where you had massive detention without trial, and you had just the overwhelming abuse of human rights. And that was in the 80s. But even before that, if you look at the history of the country, even in the earlier colonial time, where there was land and other forms of deprivation, and treating of people as completely second-class, third-class citizens, really, that provision in the Constitution was important to enshrine equality, liberty, and those kind of rights was an enormously important part of the Constitution, and it remains so.
I want to draw some attention, of course, to certain provisions of the Constitution, particularly Article 11 and Article 12. As a human rights lawyer, you had to deal with a lot of issues around arbitrary arrest, detention, etc., etc. Talk to us around the thinking of the Constituent Assembly in terms of the way they constructed Article 11 and 12, where the presumption of innocence, of course, is the major consideration, and things such as arbitrary detention is really dealt with.
Yes, detention. That was actually quite an important issue during those deliberations, because in one of the early drafts, one of the drafts provided for, which was supplied as a discussion document, provided for up to 2 weeks detention without trial. And
so before the 48 hours we have now, it used to be 2 weeks.
No, it wasn't 2 weeks. It was never 2 weeks. It was often indefinite detention without trial. Under the Terrorism Act, even under the old AG9, many people in this country of my age and more will remember it was up to 30 days, which could be extended by the Administrator General indefinitely. And people often held for years without trial and without access to their family members, without access to lawyers. That's what happened. Now, in one of the drafts that served before the Constituent Assembly, it was 14 days was detention without trial. And I was certainly very much opposed to that. I felt that it was extremely important for us to make a complete break from the past and have no detention without trial. You just have what you have in most Western democracies. You have in most criminal justice systems which work where you have a balancing of rights. You do have a period of up to 48 hours where people can be detained after they've been arrested, but then they have to be brought before court. And that's what we've got in our Constitution, and that's what you'll find in many countries in the world. But it wasn't a given. There was some discussion that there should be some reservation of detention without trial with up to 2 weeks. And fortunately, under the late President's leadership, that was soon dropped in the deliberations. It was dropped, and it was decided there'd be no detention without trial, except when there's been a state of emergency which is declared. And even then, when a state of emergency is declared, there were some protective provisions there that a state of emergency couldn't just be declared in the opinion of a specific president. It would have to be something which could be tested in a court of law. So there were very important provisions there that protected people, and that was critical to make that break from our past where people's rights were trampled on, to have a new system where you did not have that experience. And of course you mentioned 12, and that's the right to a fair trial.
Fair trial, yes.
Because a lot of the cases, my clients with the political offences, there were all sorts of presumptions of guilt, not innocence, that our clients had to face in those proceedings. And that was all done away with. It was even done away with during 435, but it was important in the Constitution to say none of that in the future. You are presumed innocent.
Until you're actually brought before a competent court of law. And that competent, if one looks at that as well, many people reflect on it and say that if you read the two provisions, of course, the entirety of and the spirit of what the Constitution provides for, that fair trial also comes with the support of legal aid. And that's where, of course, it enters the conversation around the Legal Assistance Center, et cetera, et cetera. Talk to us about the importance of the state also providing legal aid for people to be able to defend themselves in front of court, or to have a competent lawyer defend themselves, being paid for by the state through legal aid and other support.
Yeah, that's a very important component of a right to a fair trial. It's also the right to be represented, and especially in serious cases to have someone actually represent you. Unfortunately, it's not a reality in practice for so many people who come before the courts, especially in the magistrates' courts, but in cases that are where serious crimes are involved. The more serious crimes are involved, which would involve the potential of a long period of imprisonment if you're found guilty, you then are entitled to be legally represented. We would like to see, and I'm sure the Minister also would have said this if you'd asked her, we'd like to see more legal aid being granted. We'd like to see that budget being bigger so that you'd find more and more people would have access to legal representation during proceedings. But at this stage, it is a right which is entrenched by the Constitution and was interpreted by the Supreme Court. You remember the time of the treason trialists, the Supreme Court said, and where it says very serious offence, people are entitled to be legally represented.
And the Legal Assistance Center, of course, you're also one of the founders of the Legal Assistance Center. Reflect on the role of the center at that time, and what were some of the major issues that you had to deal with under the Geingob administration as the Prime Minister?
Well, the center was set up before independence, and it was set up to address the human rights abuses happening in the country, and particularly in the far north of the country where the abuses were the most rampant. And the centre was set up to address those at a time when there was very little prospect of actually the implementation of 435 and independence. And that was when it was set up, during those very bleak and dark years when it was a huge struggle to assert human rights in the country. And then, of course, we had the dramatic developments of the implementation of 435 and the right-giving constitution which came about at independence. And then when President Geingob was the first Prime Minister, the LAC continued. I was still attached to the LAC at that time. And the LAC played then a completely different role, which to obviously still to remain true to its principles of human rights protection, but at the same time also getting constructively involved in initiatives which were going to be right-giving in themselves. For example, like when the land conference was held, which was an important initiative of Prime Minister Geingob at the time, a very, very important initiative because it was the most pressing constitutional issue at the time in the country, was the imperative to address land redistribution. So the centre then got involved in issues like that, gender equality, to try and bring about interventions which could lead to more gender equality and issues like that.
On that land issue, do you think, I mean, having worked with it in that conversation around Article 16, do you think it was too much of a compromise? Some believe that Article 16 was too much of a compromise and we should have looked at a different direction or something more direct in terms of land, the land redistribution question and the question around expropriation.
It was a compromise that was made. I think there were a lot of compromises that were made at the time of independence, very important compromises to bring about a peaceful transition, to bring about national reconciliation, which was the important policy in those first years which helped to heal the nation. So it was one of those compromises. I think that you mustn't just see Article 16 in isolation. In isolation. You will see it in the context of the affirmative action provisions in the Constitution, which provide for affirmative action and which you'll find reflected in some of the land legislation, and to provide for initiatives to assist previously disadvantaged people acquiring land. If you ask me whether it was, I'm not really sure about that. I had hoped for something a little bit more affirmative to address the serious problem of land redistribution. But I certainly think it was an important compromise, and I think Article 16, you can still have expropriations taking place. You just have to provide for a fair value. And when you look at a fair value, you can also have a look at the historical context within which farmlands were acquired in order to assess and determine that. So I do think it was a very important compromise, but I respect it, but I don't think it's the final word on redistribution.
But one of the things, of course, one looks at with regards to that, the work that the LAC had also done was making sure that the access of justice, not only from an information perspective, that people are also able to access courts and so forth. Reflect a little bit on the work that needed to be done to develop those structures, and what you make of the work that the government of the time, right after independence, were putting in, the efforts that we've been putting into sort of create those structures for the access of justice.
Yeah, those are really important initiatives at that time. The LAC did a lot of work in educating about human rights and about the new order. And that was really critically important, to explain to people how to assert their rights, how to understand those rights and the context of those rights. And gender equality really has been a very important issue in the country following independence because of the inequality that you had before that. But what also happened within government was that under the new administration, and especially with President Geingob as Prime Minister at the time, had a lot to do with setting up a lot of the structures within government as Prime Minister. There was a lot of setting up of structures in order to make government more accessible and work better for the people. So there were a lot of initiatives at that time, and the LAC in many instances also worked quite closely with government in order to try and assist people in asserting rights and understanding what they were.
In terms of that, I think one of the most important things that he also spoke about always was the issue around transparency and accountability and the independence of the institutions. Reflect on your time, of course, as a justice, and in terms of the independence of the judiciary in the function of your work.
Yeah, that's key. The starting point is that the very first sentence in the Constitution really is that the adherence to that the Constitution is based upon the rule of law and the principles of democracy. And inherent in those values are accountability and good governance. And the President did always stress those. And I think those are very important. And when he became president, it was always something that he stressed every single year at the opening of the legal year. We have that formal function. His first premise was always that the government respects the independence of the judiciary, because that is a cornerstone of the Constitution. You can't have a proper democratic constitution without having the independence of the courts being recognized and upheld. And it always was his unequivocal position. And he always emphasized that. And it's something which, as a member of the judiciary, we always valued and appreciated. And it was something which we also commemorated this year, very shortly after his death, when we had the official opening. It was emphasized by all three speakers that his commitment was always there. And I will say to you as well that the commitment was also there on the part of previous presidents. But he was extremely strong on that issue. And I think if you look at his background as well, and his adherence to the principles of accountability and transparency, which are inherent in the very essence of the Constitution, those definitely shine through in that. And I think if you look at the transition after his death, I think it's also manifested there that we've had a very smooth transition in accordance with the Constitution, and you've had something which I know a number of countries would be proud of. And certainly Namibians can be proud of that we had a transition which was both smooth and constitutional. And that important commitment to constitutional governance was something that he always stressed. And it was also very gratifying to see that it continued and operated on his death too.
In terms of that, of course, we know that some provisions, some amendments had to be made to the Constitution. 3 occasions, the first one being that one of course, the extension of the presidential terms. Many felt the President Nyoma was not directly elected, it was by the Constituent Assembly, so the third term came into play. But more recently, of course, those changes around that ensured the independence of judiciary from government in terms of its administration, and those amendments around the Vice President. Let's look at the separation now with the judiciary and that independence that they got, and those amendments that took place. What is the importance of that separation and ensuring that it actually happens in practice in terms of how the judiciary is administered and not just in the Constitution as a philosophical ideal, for lack of a better word?
Yes, it was initially in the Constitution. It's always been in the Constitution. But in 2014, there was an amendment which took place. He was then, I think, the Prime Minister.
Yes.
When it occurred. And he fully supported that amendment. And that amendment was for, and some of us in the judiciary were particularly keen that this should be passed, was an amendment which would just reinforce the independence of the judiciary. As you say, it's there, but you want to actually manifest it more strongly and to make it more strongly in practice. And that's what happened with that amendment, because it set up the office of the judiciary, which is essentially separate from the executive branch of government. And that just entrenches its independence, so that it determines and essentially its own budget. Obviously the executive, there must be some interplay with the executive to get that vote through, but that is all determined. How the money is spent, on what, and what should come to it is the first call of the office of the judiciary. And that really is an important practical manifestation of independence of the courts, and it's one which he certainly very strongly supported.
But I think, in conclusion, what is the legacy, in your opinion? What kind of legacy does he leave in the administration of justice in Namibia, and generally overall jurisprudence in terms of the overall body politic of law of Namibia?
His legacy is massive because of his role in steering. His pivotal role in getting us our constitution. And he played such a crucial role in the adoption of the constitution. And that is such an important legacy, because the constitution governs us. And the constitutional democracy within which we operate, the courts are independent, and the courts have developed that constitution and will continue to develop it. It's a living document. And that is his legacy. Was that, I'd say for me, it's his most outstanding legacy as far as the law is concerned, because he had such an important role in setting that constitution up with its liberal, democratic governance framework, where rights are protected, independent courts, limitation of terms. Those are so crucial. And he had a pivotal role in that regard. And we can be very grateful for that important role that he played.
Thank you very much, Justice, for making time out to join us for this conversation.
You're welcome.
Justice Dave Smuts, reflecting on the life and times of the President, of course, within the ambit of the law, of course, the founders of the Legal Assistance Center, and a human rights lawyer by practice even before independence, just reflecting on the thinking and some of the philosophical underpinnings within our Constitution, particularly with regards to detention and arrest.